The case of People versus Rideout presents one of those set of perfect storm circumstances that produces an untimely death. Rideout's driving drunk. He hits another car driven by Rachel and his passenger Kaiser, our soon-to-be victim. Neither were seriously hurt, but the car was damaged and it had no lights that could work. The car was sitting near the center divider, while the defendant's car was by the side of the road. This is a scene that plays out on streets all the time. Here's where the problem occurred. Rachel and Kaiser were on the side of the road conferring about what to do. They saw that car sitting in the center divider. It's a dark street. They were concerned about the car. They go back to the center divider to try to get the flashers, those are those hazardous lights, to try to get them working. They're concerned that on this darkened road, a car might hit that car without seeing those lights. And they also knew that they were physically in danger from other cars because no one could see them on the road. That's why they were trying to connect the flashers. So what happens? You guessed it. An oncoming car hits passenger, killing him. The question is whether defendant, who started this whole mess by hitting Rachel's car, should be responsible for killing the passenger. That sounds odd because we know that it's the oncoming driver that's the direct cause of Kaiser's death, the car that actually hit him. But still, we want to know whether Rideout bears responsibility because, after all, he had the initial car accident that made everybody vulnerable. The Rideout court lays out the two steps of analysis beautifully. There are two steps that we always have to remember. First, we need to prove the factual causes of Kaiser's death. That's where the but-for test comes into play. So we do our but-for test to see who are the factual causes. But we can't stop there. Second, we need to decide from these factual causes which one should be the proximate or legal cause for this criminal homicide. We have to add this second step to the analysis because it would be unfair to blame defendant for every action that occurs after he's set in motion following the car accident. Adding this second step is designed to prevent criminal liability from attaching to conduct that occurs after defendant's acts that are really too remote or unforeseeable. Here, defendant was a factual cause of the ultimate death. Here comes the but-for test. But for his car accident, and probably as having been drunk, Kaiser wouldn't have been in a vulnerable position. He wouldn't have ended up in the center divider to have been hit by the oncoming car. So that's one factual cause. But there's another one, and we're going to use the but-for test. But for this oncoming driver hitting Kaiser, he wouldn't have died. So we've identified two actual causes. Defendant, Rideout, who had the initial car accident, and the third person who drove the other car. Where there is another force or forces after Rideout acts and before victim's death, that's called an intervening act, and we need to ask whether our defendant's actions are too remote to still be the cause. The court highlights 6 factors to consider when we have an intervening act to help us determine whether that intervening act could be superseding and cut the chain of causation, or whether defendant should still be on the hook. The first is when defendant's conduct is de minimis contribution to the risk analysis. An example of this is what we've already previously described. Defendant shoots the victim, but the ambulance crashes because of an earthquake. If you only relied on a but-for test, you could find defendant responsible for the death. But for shooting the victim, he wouldn't have ended up on the road when the earthquake hit. But that doesn't make good sense. Under the de minimis test, which is really an unforeseeability test, D hasn't really contributed significantly to the result that happened. The second is what we call the intended consequences doctrine. If the victim dies as defendant intended, even if the circumstances are a little different than defendant planned, defendant should still be responsible for the result. The third is where the intervening act committed by the victim or third person is an omission. Generally, and I emphasize generally, that omission or failure to act doesn't supersede defendant's intentional behavior. Generally, it won't be sufficient for a supervening act. But I say generally because sometimes failures to act that are intervening acts could be more problematic and more egregious. So only generally won't it supervene. Fourth is the foreseeability test, and for us that really is the major test. Is this intervening act reasonably foreseeable when defendant engaged in his behavior? If it is reasonably foreseeable, defendant is still going to be responsible. If it's not reasonably foreseeable, defendant won't be responsible. That's the broader question we're going to ask. Is the intervening act something that would have been contemplated when defendant set in motion this chain of events? Fifth is what we call the apparent safety doctrine. Where defendant's active force has come to rest in a position of apparent safety, the court's not going to follow it any longer. Or stated another way, where victim is in a position of apparent safety, defendant should no longer be responsible for actions occur after that. I want you to dive into the Rideout case because on this point, there's a case built into Rideout that's really instructive. It's called Pressler. There, a woman ran away from her abusive husband. He's threatening to kill her. So she runs out of her home into the freezing cold and runs towards her father's home. But she never goes inside her father's home. She actually freezes to death outside because she chooses to freeze to death rather than go into her father's home. Should the husband, the abusive husband, be responsible for her death? To analyze this question of homicide, we're still going to use our two-step process. First, we're going to determine what the actual causes of her death are, and then we're going to determine the proximate cause. So, one is her abusive husband. But for his abusing her, threatening her with death, in essence chasing her from her home, she wouldn't have been vulnerable to the cold. Okay, that's number one. But we actually have a second actual cause. That's her herself. She's an actual cause. But for her choosing to stay outside in the cold when she could have gone into her father's home, she wouldn't have died. Both are but-for causes. Both are actual causes, as the court notes. Now we've got to figure out who's the proximate cause. This is where the apparent safety doctrine comes into play. The court in Pressler said the victim had reached a place of apparent safety. She could have gone into her father's home. She did something to endanger herself. Therefore, she's a superseding force. She cuts off abusive husband's responsibility. Voluntary human intervention, which is the sixth factor that describes an intervening act, is also relevant in the Pressler case. Where the intervening act comes about from the voluntary and free choice of the victim, we might relieve defendant of liability. In Pressler, the victim made a free choice not to enter her father's home, and therefore the abusive husband, the court noted, shouldn't be responsible for her death. The court was quite clear and a little judgmental that this woman should have gone into her father's home, so it was her fault for freezing to death. Now, this took place in the 1880s. Do you think the court was correct in this view? Do you think that there might have been other factors that could have played on why she didn't enter her father's home? According to the appellate court in Rideout, both the apparent safety doctrine and voluntary human intervention are applicable theories in looking at the intervening act in Rideout. First, our passenger, Kaiser, was safe when he was standing on the curb. He chose to go back to the car on that darkened street without working lights. He was safe, and then all of a sudden he made himself unsafe or vulnerable. Similarly, our sixth factor, voluntary human intervention, could apply as well. Passenger entered the roadway as part of a voluntary and free choice on his part, knowing that he was putting himself in danger. He had a good reason, but it was still a voluntary and free choice. The appellate court in Rideout thought that these two doctrines at play, apparent safety doctrine and voluntary human intervention, were critical to the case, so much so that the court vacated the judgment against the defendant, absolving defendant of the death of the passenger. The Supreme Court partially reversed. It focused on the reasonableness of the passenger's behavior. It concluded that if properly instructed by the trial court, a jury could have found that Kaiser's actions were reasonably foreseeable. After all, it is foreseeable that a victim of a car accident might run back to the car to get it off the road, to retrieve items from it. So it's not so clear-cut that passenger was in a position of apparent safety and voluntarily on his own entered to the center divider, so much so that defendant's actions no longer mattered.